With the Boston bombing suspect in custody, we've heard a lot lately about the Miranda warning or the Miranda rights, and I wanted to explain those to you. Hopefully I can clarify the situation. Miranda, of course, is not in our Constitution. Miranda came about as a result of a 1966 U.S. Supreme Court case, Miranda versus Arizona. Miranda had been arrested for domestic violence, and after the arrest, as the result of questioning by police officers, had apparently made some incriminating statements which were then used against him at trial. The United States Supreme Court found that Miranda's Fifth Amendment right to self-incrimination and the Sixth Amendment right to an attorney were violated, and hence thereafter we now have the Miranda warnings, the warnings that say you have the right to remain silent, anything you say or do may be used against you at trial, you have the right to an attorney present, and so forth and so on. Really the thing to understand about Miranda is they are only important if the state is attempting to introduce incriminating statements made by the defendant at trial. There's a three-step process that you need to look at to see if Miranda applies. And the first process is the person has to be under arrest or in custody. The second step is the police officers then have to have had interrogated or questioned the defendant. And the third process is the defendant, as a result of the questioning, made incriminating statements. So that's when Miranda applies. Now in Georgia, I get a lot of phone calls from folks who have been arrested for DUI, and they say that they were not read their Miranda rights. Does that mean that their DUI case can be thrown out? And generally speaking, the answer is no. Georgia courts have consistently held that Miranda does not need to be read prior to the officer requesting that you take what are commonly called field sobriety evaluations, such as the HGN, the walk and turn, and one-leg stand. Now we all know that these evaluations are generally used against you at trial and introduced into evidence, but Georgia courts have held that Miranda is not necessary. Why? Because the first step in the process has not been met. You have to be placed under arrest by the police, or you have to be in a position where a reasonable person would have believed they were in custody. In other words, perhaps maybe you were handcuffed. So generally speaking, Miranda does not apply in a DUI case. The only time I can see that it would apply would be if you were placed under arrest and then the police officer started asking you how much you had to drink, you made an incriminating statement, and then the state wanted to use that statement against you at trial. That's really the only example that I can think of where Miranda would apply, and your statements would probably not be admissible if the officer had not read Miranda. So I hope that explains Miranda. I know there's been a lot of talk about Miranda on the TV lately. Hopefully that explains Miranda for you.